Lindsey's birthday, I've been out since like.
I sure did.
But I don't come this way too much. From the meeting yesterday.
Oh, yeah.
Was it weird?
They didn't work here.
Together all at the same
I
time.
knew they weren't working.
No.
How many bits of crew they got going on?
Hold on, before you have
I was joking with him yesterday. Yeah.
Well, you're getting more than ability to run an inning show.
You take it quite literally.
Good. Good thing you're getting a new system.
Boy.
Duct tape for that?
No,
It's not the new one yet.
we got a bin out back.
Okay.
How are you?
Good yourself.
I'm doing all right.
How's Pam?
Well, my wife's coming home today.
Oh.
For 3 months.
Cool.
And then my youngest son's wife decided to have a baby this morning, so everything's okay. I wanted to try to do it.
Yeah.
That's a lot, that's a lot.
So, boy, girl, how do you?
That's a good one. Yeah, it's about this happening.
Exactly.
Okay, in process. Okay.
All right.
Did you get the whole thing? That's the whole thing. He just handed them out. Jeff just handed them out. All buckets. Yeah. So I don't know if they're back there, so.
Good morning.
Morning.
I wasn't supposed to be, but my truck for work is coming in late, so.
No one knew. Guess she's dead. I'm gonna call you on it. I'm not anymore.
No, just checking it.
Jeff, are there additional pages? Are there other pages?
There's stacked.
Oh, flip one.
Good morning. Good. Yeah, yeah.
Smile. Yeah, you got a lot going on today. So. Mhm.
And we should just read all that one.
Justin's watching. Justin Kasner.
Jerry's on a conference thing.
Julie's gonna take a break. So she hadn't had her break yet.
Yeah. Maybe a chair.
Okay, it's 11 o'clock, and we call the meeting to order. And I'll leave you the pledge of allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Supervisor Bosner.
Here.
Here. Treasurer Kowalski.
Here.
Trustee Woods.
Here.
Trustee Wright.
Here.
All five present.
All right. Do we have approval of the agenda?
Yes.
Okay. Wayne?
I'll second.
Okay. And Nick? All those in favor, signify by saying aye.
Aye.
All those opposed, same. Motion carried. This time we'll open it up for audience comments on agenda items.
So Supervisor, do I get a chance to speak during the appeal portion, or?
Yes.
Okay, I don't make comments.
Okay. And then we'll move on to special order of business, consideration of the appeal by Richard Lindsey of Freedom of Information Act response. Do you wanna say anything now, or?
First of all, I want to note for the record that I've designated pursuant to our rules, the township attorney to record the proceedings of today's meeting, since the record is subject, or it would be potentially an appeal to a court. Also, I want to note that I have had previously designated the township attorney under the Freedom of Information Act to respond to the Freedom of Information Act request that was filed by Mr. Lindsey, dated November 26th. And at this time, the appeal before us was dated December 21, 2024. It was filed by email. Dear Supervisor Bossert, please consider this appeal of the determination letter dated December 20, 2024 of the following. 1, partial denial of my FOIA request dated November 26, 2024 based on MCL 15.243 (1) A and MCL 15.243 (1) G, and 2, imposition of a fee for providing the requested records. The records being requested are in the public interest, and the fee should be waived. Sincerely, Richard Lindsey. That is the appeal.
I guess at this time, Richard, you'll like to address us.
Thank you for the opportunity to speak to the board this morning. Obviously, the appeal lays out,
Mike.
the appeal lays out
Could you use the mic, please?
The appeal lays out the legal basis for my appeal, and I just want to remind the board what this relates to is the special meeting that was called on the night of the Christmas parade, and was called by, I believe, I'm thinking 2 of the board members, pursuant to the board rules, and it was to take, purportedly reported on social media, to take some sort of emergency action for things that had to be done immediately. And so my requests relate to how that meeting came to be, the emails that went back and forth, because of course, if the board is aware, if there are 3 board members debating things, discussing things, setting up the meeting, that is potentially a violation of the Open Meetings Act. And so that is what I'm looking for, is that kind of thing that went back and forth. Part of what the appeal is based on, so there's a part that deals with attorney-client privilege. I don't know what the attorney-client privilege is, so I can't really speak to that because I don't know. I'm not sure what the private interest would be. The other exemption is for basically private communications. So anything that's regarding township business should be talked about using township email. If you are using, if any of the board members are using their private emails for township business, my position would be, my position will be with the circuit court, depending on how this goes, but that is subject to FOIA and should be released. So I don't know what that would be. All I get from the attorney is just a statement of what the exemptions are. So I'm asking to have those things produced. And then the fees, so, I mean, the first and basic thing is that you should have all the records. They all should be available. They're part of what belongs to the township. You should be able to do a quick search for emails among the township board members for that particular purpose, and it should take about 5 minutes to do it. You have the documents, they're available, and you should be able to turn them over without charging anything. The other thing that it is in the public interest. You know, what you do and how you communicate with each other is in the public interest, and that is the basis for providing an exemption from the fees under the FOIA statutes. I request that you uphold the appeal and grant the records being produced. Glad to answer any questions.
Okay, Seth, would you like to?
Okay, so anytime a township board holds a FOIA appeal hearing, the township clerk read out loud the appeal letter, and then Mr. Lindsey was given an opportunity to describe the request, and he placed on the record why he feels that the fees should be waived. The FOIA statute does allow fees to be waived if there's a public interest, but this is in discretion of the board, whether or not it wants to waive the fees associated with this request. When Mr. Lindsey submitted that request, my office prepared a response. We asked for a 10-day extension, and then with most FOIA requests, if not all of them, we look to see if we have to do a cost estimate. In other words, what that requires is how much time it takes the township or even our office to review the request and to determine what those costs are. So any request that's over $50 as a cost estimate, the requester is required to pay half before the township actually starts processing the request. And part of what we're required to do at an appeal hearing is go through and do a calculation to locate the records. And under the FOIA statute, we have to use the hourly rate of the lowest paid attorney at the township capable of reviewing and finding, these records to be able to locate them. The number that we had was $15 an hour. I think after today we're going to confirm whether or not that's accurate. Make sure it's more. That's the last number we had. Okay, there's thought that it might be more now. But for the purposes of today, that's the number our office had, and we're looking at the statute. There's no authority to actually, to amend it. So we're going to go by what's on the cost estimate for today. And what you do is you got to break it out in increments of 15 minutes. So we use the hourly wage of $15. So that's $3.75 per increment. 2 increments, so the total we feel is $7.50. Now that's not a lot of money, but if it turns out to be more, then that's how the estimate gets adjusted. Okay, and then the requester is required to pay the full estimate. And if he doesn't, then after 48 days, the request is considered abandoned and there's no further action. So the next part of this is this FOIA statute does allow for the township to charge a fee for contracted labor to go through, determine whether or not we have to separate exempt from non-exempt matters. The FOIA statute provides for certain exemptions where we would redact for various issues. In this case with the township, I think more than likely it's going to be attorney-client privilege. Other examples can be if there's a personal identifying information that we think is too much of an invasion of privacy. It does set out, the statute does talk about how much money we could charge for the hourly rate, which right now is $61.96. So per increment, again, 15 minutes, it's $15.49 per hour. And when our office does this, we sort of base it on what we think, based on our office's experience of how long it would take to review. We feel it would be 22 increments to be able to properly review this FOIA request to review and separate exempt from non-exempt materials. So the total labor cost would be $340.78, which brings the total cost estimate to $348.28, which again is the combination of $7.50 for the labor cost to locate and $340.78 for the contract labor, which is our office, for the cost to redact, which again is a total of $348.28. So that would be the number that the township would be considering whether or not to waive today. And I think there could be discussion on this of every board member and how they feel about whether or not you want to uphold it or waive it, and that would be done by motion. So looking through, there's a couple of different options that the township has. After your discussion, I'm going to recommend that you're going to have to vote on whether to either uphold the fee, reduce the fee by a certain amount, or waive the fee entirely. And if you uphold or reduce the fee for this appeal, the FOIA coordinator will need to provide a written response explaining the reasonings for this decision in accordance with the FOIA statute. So in this case, my office would just prepare a letter indicating if the fee is upheld that they have to pay, or if it's reduced, the reasons why the board came to the conclusion that it did. So that's the extent. I feel that we're in compliance with the Freedom of Information Act for this appeal hearing. It was properly noticed. Mr. Lindsey was given ample time to, and I believe he confirmed his availability for today, and in fact he was here today. So the next part would be just for the board to hold a discussion and place its reasoning on the record of why you want to either uphold, reduce, or waive the fee. And when someone's ready after discussion, a board member can make a motion to the effect of either upholding, reduce, or waive. And if I need to write a letter within 10 days, depending on the board's decision, we'll do that. So I have nothing additional to add. I'm happy to answer any questions, and if there are none, then I recommend the board enter into some deliberations on this matter.
Seth, if the board decides to either reduce or just do away with the cost incurred by your firm, does the township end up owing that to the firm then?
Yeah, that's the cost incurred.
Okay.
Yeah, unfortunately, that's how the statute reads, and yeah.
Does that include today's attendance?
Correct. Let me clarify that. For the appeal, it's just, we can only charge for reviewing exempt and non-exempt materials. Okay, so the cost of today is not considered in the fee appeal. Okay.
Couple of questions. Number one is, just so people aren't any more confused than they might already be, there are two, when you say charge, the township is charged today for your being here, as I understand it, but the Freedom of Information Act does not allow for that to be a charge to Mr. Lindsey.
Correct.
And your billing to the township, even for the redaction, may be in excess of the $61.
Correct.
And so the township, regardless of the status of this appeal, absorbs that as well.
Correct. And unfortunately, that's common township to township.
Right. That's the law. Legislature makes the laws. So we're stuck with applying with everything. Okay. The next question I have is, are there documents well, let me back up a minute. This all occurred during it's not quite as simple as was stated earlier by the appellant with regard to retrieving emails, etc. It's only now a little more easier because we did switch to a separate server for emails. But those emails are for emails either we receive at an official township email address or that we send from an official email address. So unless we're copied, each of us individually at our township email addresses, it would not necessarily be on that server unless somehow we copied somebody from the township. I think that's how the server I was instructed works. So it is a little bit easier than it has been in the past to retrieve emails because before it was on our general server and was mixed in with every other document and every other communication that's on there. My question goes really to, during this particular time period, we're gonna have to look at it carefully and get some further information if that's necessary. But during this time, it was the time of the changeover, the three officers who requested the special meeting in writing to the clerk were new members of the board as of noon on November 20th. And I don't believe it was at varying times thereafter that they received and were activated their email accounts at the township. So any communication that was emailed prior to the activation of those accounts would have been a private email. Obviously the township, unless the township received a copy or somebody at the township received a copy of an email from a private email address, we wouldn't be privy to knowing whether or not there were any emails.
Correct, and this is actually a common occurrence. So there are times where board members, either their account's not activated or they for whatever reason they confuse accounts, where they send an email to another official from a private email address, like your Gmail account or something. That's still a public record. Okay, subject to FOIA. Text messages, or that's if it's about municipal business, that's subject to FOIA. So a lot of times when we get these requests where it says any communications, a lot of times townships are just drawing, okay, let's search our emails. Well, yeah, that's part of it, but also you need to check if there's text messages, and there's various levels of whether that's common or not, or whether there's emails sent from private email addresses that aren't township accounts. And there's other times, sometimes it may not be relevant here, but if you reach out to a professional contractor, like zoning administration, engineer, my office, things like that, those are still public records. There might be an exemption that applies, but you still have to get them. And then if an exemption applies, you send out what is subject to that exemption.
Okay. Then my next question is that are there any documents to your knowledge that would fall within the purview of disclosure under Mr. Lindsey's request that are not in need of being reviewed for redaction? For example, I believe what would fall under them, two documents, and they'll be obvious in a minute. One is the agenda for the meeting, which was published to our website. The other was the notice of the special meeting, which was also on the website. So those would be disclosable, obviously, because they're public, and would not be subject to this, or would they be included? They would be included in a response, but they wouldn't have redaction work.
Correct. So those are two common, the agenda and whatever's posted. Those are obviously going to be public records, subject to FOIA. I can't see how any exemption would apply. If Mr. Lindsey's request was just for that and it was on the township website, the response would be granted, but it would be pointing him to where those documents are. In this case, that's part of the response, but not the entire response, which is why we had the 10-day extension and the cost estimate. So it's just a little bit different. There are going to be, there's going to be records that aren't going to be subject to attorney-client privilege. And if there's emails between any board members, or if you send out an email to the board that says, hey, here's the agenda, or here's the special meeting notice, that's not going to be, that's a public record subject to FOIA. There's not going to be an exemption applied. In this case specific with Mr. Lindsey's request, I would just think that if there's questions that came to my office about, FOIA generally, leading up to this meeting, or how to get, legal opinions in that regard, that's where I think the exemptions would kick in.
Okay, that really speaks to, because I think you set out a good explanation of point 2 of his appeal, but the appeal had two parts to it. The first was of the partial denial of his FOIA request dated November 26, 2024, and what materials were provided to him that weren't denied.
For the November... Pursuant to his November 26th request, it was stated that he was appealing the partial denial of that request. Was the denial entirely based on the fee, or were there documents that could be provided? So Mr. Lindsey's appeal was for the fee. So my understanding is that there were two FOIA requests. There was one that was on, you just provided the date, November, it was in November 20.
November, that's the one he is appealing.
Right, and then that was followed up with the December 4th supplement that asked for the text message. I treated that as one. It said, okay, here's your request, here's the supplemental. We did the 10-day extension with cost estimate. As far as I know, no records were produced to Mr. Lindsey since that response letter went out from my office. And then once he got the cost estimate, that's when he did the appeal, and here we are.
I guess what I'm getting at is that in the end, could a possible action of the board be to authorize you to release those documents that can be released, that don't require review and redaction, and potentially redaction, and uphold the fee with regard to those that require review and redaction? Is that possible?
It could get a little complicated. Because we're talking about trying to process a couple of different, requests, and the cost estimate is based on first for the township, the labor cost to locate all those records. Okay, and then secondly, we would still review to see if there's any exemptions that apply. So if we go that route where we're reducing some, or not reducing, but if we're authorizing the release of certain records and not others, then the question would be, how does that impact the cost estimate? So if you do that, then I think the recommendation would be review the cost estimate and see if it's appropriate to reduce it. And that's where I'm saying it might get a little complicated. Does that make sense? I know that's maybe a little bit confusing.
Yeah, it's kind of one of those chicken and egg things.
Yeah.
Which one came first?
Okay, in his appeal, item 1 there, the partial denial of my FOIA request, what triggered the partial denial?
So with the partial denial, it might be if a record exist, okay, and we have to look at that again a little bit more closely. But then also we have to look for something that's going to be exempted out and not, but not subject to disclosure. You know, in this case, we did a 10-day extension in the past. That's he's appealing the cost. So that's what we're considering today.
A question, I guess to the FOIA coordinator. Was the full address of the requester included in the FOIA request?
So when we say the full address, like your actual address, like physical address, no, that wasn't included. It was an email. Okay, I believe I double checked that after that question was raised to me. Under the FOIA requests, under the FOIA statute, it does require an address to be contained in there in their request. It wasn't. My office tends to be a little bit conservative with how we process these, so we made, yes, that was noted. We made the decision to go forward to avoid any. We try to keep everybody out of court. Okay, so that's that's the reason why we moved forward. And if there's a direction from the board that in the future, you know, we don't do that. If it's not a complete FOIA request, then we'll follow it.
So just to be clear though, MCL 125.2331, section 13 does state the request must include the requesting person's complete name, address, and contact information.
That's correct. That's an accurate reflection of the statute.
So I just want to make sure. So if we're talking about the cost, I think looking at and reading up about FOIA, I think the question then becomes on whether it's waived or not. And myself reading those sections, and I just am making sure this is clear. A lot of the questions revolve around whether it's in the public interest is normally the deciding factor of whether a board will waive the fee or not, in at least in precedent history. Is that correct in making those judgments?
That's correct. It's within your discretion. Okay, whatever your decision is, whether to waive, reduce, or uphold, I would just ask that the board members specify their reasoning so there's a record made. So if there ever is a challenge, we are able to say why the board made the decision it did.
I guess, you know, at least something to consider, at least in thinking about this. Mr. Lindsey referred to on social media, it was presented, I think Mr. Kowalski initially put up there was going to be a special meeting held before it was publicly posted, I should say. And then several members of the community also then posted their concerns about having the special meeting happening on the same day as the Christmas parade. And I do remember Mr. Lindsey posted on the What's Happening in Marshall page that question about, like, hey, I thought they ran on transparency. You know, it's funny that they put a special meeting on the same day as this. And I responded to Mr. Lindsey saying, yes, we ran on transparency, and I'm happy to explain why it was necessary for us to meet at this time. The Township Planning Commission is supposed to meet on December 3rd. Due to the number of resignations on that committee and that they've not had a meeting since September, one of those positions is filled by the previous board member. Since Bob is no longer on the board, it has to be filled by one of the new members. We wanted to make sure that the planning commission had enough members to have a quorum on December 3rd to address the matters that have stacked up since September. While I'm sad that it falls at the same time as the Christmas parade, it's imperative that the Marshall Township government is able to function and is responsive in the needs of its residents. And there was a few more exchanges within there where I mentioned that a planning commission member had reached out to board members highlighting this concern. There were also other members of the planning commission that also responded to Mr. Lindsey, echoing that same concern that there wasn't enough and that they had concerns, and that's why they had reached out to board members asking that we consider that. So the question is, like, how did that communication happen? Did we provide information? And so, one, as a board member, I tried to answer those questions, and Mr. Lindsey then responded saying that he'd like to FOIA that information, which is his legal right and his obligation to be able to ask for those documents. But by going through and asking for those documents after receiving the information about how we came to that decision, which again, it's in his legal right, it does incur a cost to the township. That cost is there. And so it's one of those questions. I'm happy that he sees all those documents. He'll see exactly what I described in those in those documents. But by going through that FOIA process, it does incur a cost to the township. And so that is a question and a concern that I have. I will say that thread got taken down on the What's Happening in Marshall page. There were several other people's personal Facebook pages where that comment was continued to be spread, but not the response from board members on why that was the decision around that. So I just wanted the board to know the rest of that kind of part of that story, and maybe we can weigh that in whether we decide, is it in the public's best interest if the questions were answered? Again, I'm okay if we decide to do one or the other, but his not trusting township board, which is again his imperative, his ability to do so, does incur cost. And so the question then becomes, does Mr. Lindsey, should he pay the cost of knowing that it's going to cost additional funds to do that, or do we waive it and just give it to him? So I guess that's the question.
Are we in the
Comments portion, or are we still in the questions portion?
We're questions, comments, I guess.
We're in asking questions of our lawyer concerning activities around it, but nobody's made a motion to discuss the actual reduction or doing away with the fees or anything like that. Nobody's made a motion yet, so we haven't got to the meat of it yet.
I'd like to ask another question of the attorney, and that is, can you give us any further information on what the courts, when they review these things, think the public interest is versus what we individually or as a board may think?
So, anytime you go to court, it's difficult to project what a judge may find. And secondly, we can't stop anyone from going to circuit court either. Okay? I think the court's going to look at our record, okay, which is what we're doing right now. We're establishing the record. And in that record, did the board provide sufficient information for its reasoning? Like, how thoughtful was our discussion? In other words, we started this process, he asked me some questions, right, which is how it should go. And then if there was just a motion to uphold, a second, no further discussion, and, an approval to uphold, and that got appealed, the court would look at us in court and say, Township, you didn't specify your reasons. And that's, I think, where you can find yourself in some trouble. And the issue with FOIA is if there's a violation, the township has to pay the other side's attorney's fees. And that could add up. Okay, it costs money for them to do an appeal, to appear in court. We've seen it be high, okay, when there is a violation and the township is found to be liable. Okay, so that's why we make these records, and that's what protects us if there's ever an appeal.
Can I ask another clarifying question? In other FOIA requests prior, because this will be the first one that this board has taken, I'm curious, how does this stack up to how the board has historically responded to FOIA requests, and whether they choose to waive or not waive fees?
I don't know if I can answer that question because I don't know. I know that the township did incur, FOIA requests previously, and we go through the process of doing the cost estimate and sending it over to the township, and it gets forwarded to the requester. But unless we're asked for follow-up, I don't know what happens, if there's an appeal or what your decision is. There aren't too many, at least in Marshall Township, I can't recall there being, at least that I was involved in, an appeal hearing. There may have been. It's just that I wasn't here for it, and I don't know if I don't recall something that jumps out to me about whether or not there were appeal hearings.
My best recollection is that we've had a couple over the years of appeals. Generally, they've been more appeals of whether or not there were documents and whether or not they should have been released. We didn't really get into the fee aspect. There have been a number, not all that number, most of them have been relatively simple requests. They've been fulfilled and no charge has been made, and we've been, depending on, I won't use the word conservative or liberal because that depends on where you're standing, but I would say that the $50 hasn't always been, sometimes it's cost us a little more than that, and there has not been a fee, and especially where their residents are concerned, we tend to take that not totally into consideration, but we do tend to look at that, and I mean that in the case of, for example, I know that an out-of-state firm requested copies of records, and we gave them an estimate. They did not appeal, as I recall, and the reason we gave them the estimate and required it was because it was clear that the reason they wanted the records was so they could in turn sell the records. So even though they were public records, they were not available on the website, not normally available. And then we've had others where I think that's the only one that about a fee that I can recall that was appealed based on the fee. There may be others, but it would be a while back.
Can I ask a follow-up question, Jeff? Would you say that this FOIA request would you say it's more on the more complex side or more on the simple side in what you said in the previous ones that you've had?
Well, I designated because of the nature, really the legal questions that were presented with the request that were inherent in the request. That's why, pursuant to the statute, I passed on the responsibility to the township attorney to respond to this particular and deal with this particular request. Had I handled it, clearly where any private emails or texts were involved, it would have ended up being referred to the township attorney for redaction anyway. because there's not enough indemnity or liability insurance for this county for me to do that. And sometimes the job of FOIA coordinator and clerk are confused. It is not the clerk's responsibility to be the FOIA coordinator. That's a designation by the board, and not all the records are within most of our records are in the specific purview of separate departments or officers. Treasurer records are in the treasurer's domain. They're township records, but they're in the treasurer. The treasurer's a custodian of those records. Zoning and planning, the zoning administrator under our ordinance is the custodian of those records. Fire department, those are they're under the domain of the fire chief. So those requests are regularly referred to them to answer. To me, the job of the coordinator is to act as a traffic cop. If they happen to be clerk's records, then I'm going to provide them to the person as clerk in doing that. But I see the coordinator as being the traffic cop and telling the traffic when it can go and when it can't go, but I'm not driving their car.
So, I don't know if this is the right time or not, but I'm gonna bring it up anyway. So I think in the future, I would, I guess I would request it, and maybe in a future meeting, we can actually vote on this, that we reject FOIA requests that don't have the full address as required by statute. I do reject the inference of any wrongdoings that the appellate has made. I would also say it does take more than 5 minutes to find information. I'd say it takes considerable more time than 5 minutes. I personally don't think this is a matter of public interest, and specifically building on what Trustee Wright said. There have been some personal postings by the appellate that he specifically intends to recall members of the board. So I kind of reject that comment that this is in public interest. It seems to be more one of revenge.
So basically what he's asking for is any emails or text messages. So,
Yes.
is there a motion?
So I have no concern whatsoever in the FOIA request. Obviously that's all the information that was requested that's allowed by law, I think should be made available. I just personally don't think that the township should subsidize this particular request.
So I'm assuming you're making a motion, Glenn? Is that your motion is to not subsidize?
I can make a motion to uphold the motion.
I guess I will second it so that we have discussion.
Right, is there any discussion at this time?
Can we have a statement of the full motion again, please?
Uphold the fee in a FOIA the FOIA appeal that's been presented this evening for the reasons provided by the FOIA coordinator and other township board members.
Okay, thank you.
Is there any more discussion?
No, I think the question is like, again, I think it comes down to public interest. I think like that's the question. I think in that conversation I had on Facebook with Mr. Lindsey, which again was taken down, and also with the other planning commissions, the questions about how we communicate was asked and it was answered in that. So we did, in terms of transparency, I think answer that question. As Mr. Kowalski has mentioned, he has publicly on Facebook as well said that he is trying to remove or do a recall process at some point. And so at this point, the question is, as Mr. Kowalski brought up, is he looking for, is this, again, in the same line of what the public interest is, or is this, again, like Mr. Kowalski saying, around revenge, which, it's hard to parse that out. I think the thing I struggle with, too, is when that post got taken down, Mr. Lindsey continued to post and respond to other people's, but didn't continue to carry necessarily those same threads about our response from the Planning Commission members forward in communicating those responses. So that's where I kind of, like, when it comes to the public information, I agree with Mr. Kowalski, like, yeah, I think, like, how we communicate, I have nothing to worry about and hide. I don't think there's anything there that, I know that nothing we did there was wrong in any way, and I'm happy for people to look and expect those comments, but again, it's hard when it's an additional cost to the township that wasn't there before. So I think like that's where I struggle.
Well, this is kind of difficult because for the reasons provided by the FOIA coordinator, I agree that, and have had that position along, that general taxpayers should not have to foot the bill for private fishing expeditions, if anything better, or private businesses. But in this case, I don't know that not being a social media person, and not having real contact with it other than what people tell me is on there, I don't know that the motivation can be ascribed. I think it's very difficult to ascribe motivation, and you have to just look at what the nature of the records are that are being requested, and the nature of the requester. Perhaps what you said is correct. I don't have any quarrel with that. But on the other side of the coin, me telling a person that the cost is $50, and that's the cost. And if they ask me, well, how did you figure that $50? How did you come to that conclusion? Then I should be prepared as a public official to show that and show them the cost and what it is. But so to me, that's kind of the public interest, even though that individual is asking for that record to do whatever they want to do with that record, lawfully want to do with it. So I'm having trouble giving over the public interest and looking over some of the court decisions, Supreme Court decisions, Court of Appeals decisions with regard to the Freedom of Information Act, usually the requester wins, is my observation. Not always, but usually, the unit of government has to have a really sound reason to find that it's not in the public interest, for example, in this case. And I think, you may be totally correct. I'm not quarreling with that, but I don't know that for a fact. And if we have documents that show that there was a proper request in writing, and that there were lawful, that the communications between members was otherwise lawful, I don't see the harm in disclosing that, and I don't know why somebody should have to pay for that, I guess.
Well, and I think the thing is, we're not arguing about whether they should be disclosed or not. I think everyone on this board agrees that those documents are, we think that people should have the right to be able to see them in that sense. But the question is, should the township be the one to pay for it? I think it's the question. It's not, does the public have a right to them or not? We're not denying, saying like, oh, Mr. Lindsey does not have the right to look at these documents. I don't think any of us here would say anything like that. I think what we're saying is does Mr. Lindsey pay for them, or does the township pay for them?
Well, I guess, in my opinion, I don't think we should make any inferences of why he's going after these documents, and I think they should be provided to him. And it may be for the public interest that he wants them, and so he can, he can say that we did things right. So, so I guess I would agree with Jeff on this, that probably provide them without the cost.
Okay, so you're gonna make a motion?
No, we have a motion on the floor. We have to vote.
Okay,
So
vote on that.
can we talk a little bit about what the definition of public interest is? I guess, Jeff, you're indicating we have some case law. Is that something you can share with us, what that means?
No, I just said, and I've looked over the case law that's listed in the annotations under the MCL, which anybody can look up, and that's my observation. Someone else might get a different conclusion, and that doesn't really matter. I think I gave earlier an example that an out-of-state firm, or even if it was an in-township firm, wanted wholesale records that weren't otherwise publicly available from the treasurer, for example. Why shouldn't they have to pay for that? But on the other hand, if the record's available, well, why shouldn't they be provided with it? I just don't. I think the public interest versus a private interest is kind of subject to what the beholder looks at it, and I think it's always in the public interest to ascertain that a township board, a city council, or whatever is acting lawfully.
I'll tend to agree with you.
And I don't want to imply at all. I believe that meeting was requested properly, was called for properly, was held properly, and that the follow-ups, the summaries, and the minutes were properly done and even properly approved at the next regular meeting. So I don't think there's anything about it, and as you've noted, as Trustee Wright has noted, that probably no one on the board disagrees. The disagreement is whether somebody should have to pay for redaction of records. And that to me is a little more troubling, because it is a little more complicated where during this hiatus, where it was during the hiatus where there may have been, but as Seth's pointed out, that could occur at any time. Anybody could accidentally or whatever. So private emails for a public official are sort of non-existent. I mean, our own personal email addresses, if a court tomorrow said provide a copy of all those communications to the court for an in-camera inspection in a legal proceeding, we'd have to do that individually or suffer those consequences.
Can I ask a follow-up question, Jeff? And this is just for discussion's sake. What would be the case? So, like, let's say we decide not to we waive the fee for Mr. Lindsey. What would be the case where we would then apply the fee to somebody else? Like, where is the line? I just want to make sure if we're going to be completely transparent, where is that line drawn about in terms of like we apply a fee here, we don't apply a fee there. So I guess that would be a question I would ask. Where's that line?
It's a good question. I mean, they're going to get an estimate of fees anytime a redaction is required.
So I think I can make an example for you. Okay, in this case, the requester is asking for any and all communications regarding a specific meeting. Okay, and whatever the records are, the records are. But it's in some regards it's narrow. There could be a lot of records. I'm not sure. When you see requests that say, I want all communications between the township and professional anybody, like any professional consultants, planning and zoning engineer, for the past 3 years. That's going to take a lot of time. There's going to be all sorts of records. I could think of FOIA requests that had 80,000 records. When we did it, so you can imagine the cost. So that's an example of no, we can't waive that fee. It's way too much time. It's way too much costs. And I had times when people paid the fee. And, but that could be a distinction, right? And I'm not making, that's just an example. Okay, I truly don't know how many records there are in this case. It could be a lot, it may not be, I don't know.
Getting back to Glenn's question on what is public interest. I think we're inferring the public as a community. But we have a public interest out here with these 4 individuals. That's the public. We could have one individual out here that would also be considered public. So I think one individual of the public could be, that's in the public interest. Just in my form of the definition of what Glenn was asking. It's either one, several, or many, in my mind.
Point so yes, thank you. I don't want to diminish what you just said. I think it was good. I guess my question is, would we have a dollar amount, do you think, Jeff? I just want to know where the line is so that when we communicate it to other people, when we have an estimation of if we decide to waive it here, so that they understand why we waive it here, but maybe not somewhere else down the line. I think that's important. I think that line should be known. I just think that we needed to, as a board, kind of name what that is. Because I also say, this comes out of our general fund, correct? Just like elections, we don't charge people for elections when they come in and vote, right? That's part of, your right to the township of, we pay for the operating of this facility to be able to host an election. We don't charge people because that comes out of our general operating funds. Same with FOIA requests, the public have access to information from the township. So I guess that's just my question is where's our line in terms of like what that is.
I don't know that you can define it. I mean,
So just a couple of thoughts on that, right? Like when we say there's a hard line, I'm just picking a number. Say it's like $500.
Yeah.
Okay. There could be a situation where the township board might want to waive fees for something bigger than that, depending on what the extent of the public interest. Like if there is a serious incident that were to occur, and someone files a FOIA request, and they're like, no, we need to make sure this information gets out, all of it, and it exceeds $500, then the board might want to, consider waiving that, because every case is different, right? Like, so when we talk about like that line of demarcation, it's difficult for us to advise on that. Maybe there could be some sort of policy or something like that a board could review or consider, but maybe that could be something for a different matter, like a board meeting, something rather than an appeal hearing for this. Okay.
So I'm just gonna go back to so I don't have any request from December. I just have the request that was dated November 26th. So if there was another addendum to that, I don't have a copy. But it says, good afternoon, Clerk Albaugh. I'm requesting pursuant to the Michigan FOIA, a copy of all emails, text, letters, notices, meeting requests, agendas, draft agendas, or similar public records in any way relating to the setting and holding of a township board special meeting on December 2nd. I'm assuming, I guess my question there is, I'm assuming that's the cost that you associated that ended up being a half hour at $15. Is that correct?
Yes, that's correct.
So it was $7.50, and I'd happily waive that. My understanding is the next section is possibly where the costs come in. That additionally, please provide copies of any emails, text, letters, or similar public records sent by any board member to the township attorney or received from the township attorney on or after November 20th, 2024 to the present. So I'm assuming that's where some level of attorney-client privilege comes in, and you've got to go through all of these documents to understand which is and isn't and redact the information. Is that correct?
Yes, that's correct. And even if the record's subject to that privilege, we still have to produce the record, and then we have a program that redacts out what the communication is. So think about the body of the email where a legal opinion would be. Like that would be redacted. Generally speaking, the subject line would not be redacted depending on its sensitivity, but then the body of the email, that's what the redaction would be. So we still have to produce the record even if it's redacted.
So again, I don't know if the appellant has a specific, if there's one that's more interesting than the other, but I would guess that the second area that's going to incur the most of the cost is going to probably be, I'm guessing, heavily redacted documents that may not be of great value to the appellant, but I guess that's for him to decide. One last thing, in that same note, I think it ends with, if the fees are not waived, I would be glad to pay the same amount in accordance with Michigan law. One more thing, I would like to read this. This is Richard Lindsey post. Lisa Keller Reed, I did not vote for the 3 candidates in the Marshall Township. first time the options have been so distasteful, I did not cast a vote. A year from 11/5, I will be filing a recall petition for the PE. PE is his name that he applies to me.
So these estimated costs of the 348, do you have any idea? I mean, you don't know how many emails, all that stuff there is.
No, I don't. And there's a chance it's, a lot less, or there's a chance it's the other way, depending on how many, records there are. And of the requests that we deal with, yeah, this is the part that gets more expensive when you have to, go through and review everything, depending on how many records there are.
We have a motion on the floor.
Can I make a couple of recommendations regarding that motion? So I wrote down the motion. I wrote down something. So I had a motion by Treasurer Kowalski. It said motion to uphold the cost estimate fee as presented for the reasons provided by the FOIA coordinator and other board members. So there was a lot of discussion here. So maybe what we could do is look at that motion and maybe add some of the specific reasons so the board knows exactly what it's voting on. Okay, and I would recommend a roll call vote for that. So I wrote down some of the specific reasons that I heard. So the motion could read something to the effect of a motion to uphold the cost estimate fee as presented for the following reasons. Just gonna make sure this is recorded. One, that it's not a complete request because no address was contained in by the requester when the FOIA request was submitted. Two, that the requested information was addressed publicly. Three, the township shouldn't have to absorb its costs of processing the requests. The request of the records is not being denied. The records, in fact, are public records subject to FOIA, but the township doesn't feel it should have to pay for and absorb those costs of producing. So those are the reasons I wrote down. You're welcome to add to it, or to amend it, or to eliminate some of the reasons that I wrote. I just feel that it would provide more clarification for the board members of what you're voting on.
So is there any more discussion from anybody or want to add to that?
Does Glenn need to redo his motion then to add those, or?
I think Glenn could, if this is what you want to add, you can amend your motion to add what I discussed. And I think another reason that was discussed was you felt that it wasn't in the public interest because it was more of a person. Okay, all right, we'll leave that. All right, that's fine.
Glenn, do you want to amend your motion to add those reasons?
So I would amend the motion made to add those reasons to the motion.
Is there a second? Okay, right.
I'll support so that we can have a vote.
Okay, we ready for roll call vote?
Supervisor Bozzer.
I'm going to say yes.
Clerk Albaugh, I will vote no. Treasurer Kowalski,
Yes.
Trustee Woods,
No.
Trustee Wright.
I'm gonna say no on this one. So.
Okay.
There are 2 yes and 3 no.
So to summarize the motion, when you vote, you had 2 yeses and 3 noes?
2 yeses and 3 noes.
So the motion was to uphold. Okay, so the motion is no, we're not gonna uphold. Okay, and that means we're waiving.
Yeah, so then we'd have to put a counter thing that we'd waive. Does someone else, do you wanna, I guess, does someone wanna?
Would it be a motion to waive or reduce, or just one or the other?
You know, maybe for clarification's sake, okay, we didn't uphold it, so now we're waiving. Okay, so let's just do a quick motion. If there's a motion to waive the fees, then if there's a second, and you know it goes. Let's just do that so the record's clear.
So it's the question.
So the other option was to reduce the fee, is that correct?
Yeah.
So could that also be in the form of a limit of the cost? So if we said we want to make we're voting to limit the cost of the estimate that was given.
So to answer Glenn's question, we're not going to uphold the cost estimate. Okay, so what are we going to do with it? Are we going to reduce it, or are we going to waive it? If we waive it, I think that's fairly straightforward, right? If we reduce it, what's the number in one?
I think the thing I struggle with is we don't have a clear where that line is in general about where we're going to waive things or not, and I think, and just to be frank about why I went with no versus the yes on that last thing is, at the end of the day, like kicking the can down the road, all the reasons that we described. Like at the end of the day, Jeff said it, I think Dave said it, I think Nick said it, I think you said it. Like we have nothing to hide. I'm not worried about anything in these documents. And Mr. Lindsey, like we did run on transparency, and I think that he should have that. Having a reduced fee doesn't do that any more than imposing the fee at this point. I guess at this point, the fact that we don't have a line of where we'd say yes or no on something, I think we'd have to talk more about that. But I also just, don't want to kick the can down the road and have to go to incur more fees with having to go to a circuit court or something like that. I just don't think that that's worth the township's time, especially when we know that the documents show what they show. So I don't want the public to think that we're trying to hide anything at this point. So I would say I'm going to create the motion to waive it at this point.
So just before I just want to be clear. So if we're waiving the fee, are we limited in the costs that we will incur to that estimate?
Yeah, so if we waive, the question is if the fee is waived, will we try to limit our costs? And the answer is yes. Whether it's whatever the board decides, right? We will work as efficiently as expeditiously as possible to reduce any costs associated with it. If there's not a lot of records, I think we can turn around fairly quickly.
So guess that actually wasn't my question. My question was, can the cost end up costing more than $348.28? Could it cost $1,000? And if we waive the fee, then are we required to pay you $1,000?
So to follow up with that, the answer is yes. It could cost more than the cost estimate. I don't think it would approach $1,000, and if it did, I would look at that internally at my office of how to maybe handle that, because I think this is more of a narrow request, not one of those broad requests that I mentioned about any of all records related, between board members for the past year, because that would be significant.
Any decision that we make today, the precedent we're setting, how will that be held?
I don't think you're setting precedent. Every case is different. Okay, this is for a meeting and any communications that go with it. Okay, and in this case, you place the reasons, why on the record. So, the next request that comes in, maybe it doesn't make sense to waive fees because it's incredibly voluminous, right?
So we're back to case by case at that point.
Yeah, and
Okay.
to be clear, you're never going to break even when processing a FOIA request. That very rarely is going to happen, but mostly because of professional review services. And whether it's from my office or whether you have to reach out to engineers or whatever, I mean, you're gonna absorb costs for their time too. So you're not going to ever break even. And again, this could be a discussion for another day, but if you want to put more thought into it of what a policy could look like, I think that would. Let's not do that today. Okay.
I will second Wayne's motion to waive the fees.
Okay. Do a roll call vote.
Okay, I will vote yes. Treasurer Kowalski,
No.
Trustee Woods,
Yes.
Trustee Wright,
Yes.
Supervisor Bozick.
Yes.
4 yes, 1 no.
Okay. Is there any other business that may come before the board, or do you want to talk?
I guess just real quick. So we have the board decision now. I think the next step from my office will be to write a brief letter summarizing the board's decision, communicate that to the requester, and attempt to work out an expected date to get those records together.
Okay, thank you. No, go on. Is there any other? Okay. Audience comments?
I'd like to thank the board for their decision. I wanted to answer Trustee Wright as far as why I filed this. The social media is fascinating, right? I don't know who created that, so it wasn't me, but there definitely was a discussion about that. So what piqued my interest was because reading what you wrote, that there was something to be done at the Planning Commission meeting, and so I then reviewed the Planning Commission meeting minutes, and items were to zoning map review, postponed. Zoning administrator update, there's no one in place. PC bylaws, discussion, no action taken. Joint planning commission, discussion about replacing Mr. Lang on the JPC, no action taken. And so my question was, it didn't feel like an emergency, right? When I read that. And that's part of what I'm watching what you guys are doing, right? And this is the public interest piece of it. You need to do the things that you say you're going to do. And revenge is interesting. I think I have a statutory right to file a recall petition and gather signatures. So I'm not sure my motivation makes any difference whatsoever. I think you all know how I feel about Treasurer Kowalski, and you probably know how he feels about me. So I want to tell you, so at my next FOIA request, I just agreed to an extension with the township attorney on this, was the planning commission meeting on December 3rd, sorry, my phone's small, December 13th. So the minutes show that this meeting began at 9:00 a.m., and I'm quoting, en route to the business office of the South Central Michigan Construction Code Inspection address. And they go on to say what happened there. There was no public comment held. I was a FOIA coordinator for 7 years for the county. I don't think you can get in a car and have a public meeting. I think it's a violation of the Public Meetings Act, which is a violation of Michigan law. Don't know what happened. That's the public interest. So I hope we don't have to have an appeal again about this, because the public interest is that your planning commission, I'm just reading the minutes, I didn't go to the meeting, are they violating the law or not violating the law? So that's my next request. I would encourage you to grant that as being in the public interest as well. Thank you for your time.
Good morning. Bob Ling from Marshall Township. In regard to that, my personal feeling is you're trying to split hairs, because in planning commission meetings, township board meetings, when someone comes up to speak, identify yourself, and it's been the practice of either they're a Marshall Township resident or they're outside the township. And I, for one, think it's splitting hairs on Mr. Lindsey's request. So now, with what you did today, are you going to request a full address for anybody that speaks before a board or a commission? Just a general question for you. Also, when you get into the issue of you want information, is it timely? Does it take a lot of time? I often heard the comment, oh, that is readily available. You should be able to get it very quickly. Now we're hearing a statement, oh, it's going to take a lot longer than 5 minutes. It's a different side of the table, folks, and you've got to realize where you're coming from. The transparency issue is very important. And when you say the township residents want it, and Nick, you made a very good point, one person or 100 people, what are you dealing with? It was a very good discussion you had today. I can tell you put a lot of time and effort into it, and I commend you for that. Thank you.
Anyone else? Seeing none, board member comments?
I'll just say one, that just about the, I can't speak to the planning commission part. I don't know about that, but that surprises me as well. But I will say, in terms of the third, that I think one of the reasons, again, just to emphasize why we had that special meeting, was we wanted to build trust within the planning commission. They approached via email requesting something. And so we felt, because they needed something, we wanted to be responsive to them, to be able to make sure that what they care and matters is being attended to by the township. And so I'm just speaking to that in that regard of just, we take when people bring something to us, we take that seriously, whether it is a planning commission person, whether it's a fire board person, whether it's a citizen, we do take that seriously.
I think the main reason that we had the December 2nd meeting was so that the planning commission's been in a state of flux severe flux since September. There was a deep concern by both the board and the planning commission that the scheduled planning commission meeting for December would not have a quorum to perform anything. So that was the primary reason for having the December 2nd meeting, was to appoint the individual representative from the board to be the board representative to the planning commission to create that quorum. And the actions or non-actions resulting from that meeting, that's neither here nor there. There's one 2-year member on that board right now, 2 1-year members, and 3 recently appointed members on the planning commission. So we're building, we're learning. This board has 3 new members on it too. We're building, we're learning. We promise transparency, and I believe that's what we're delivering to the best of our capabilities, and we will continue to do so.
Just briefly, addressing the address issue, I think the specific comment was for FOIA requests. So FOIA requests by statute require a full address by the requester. It has nothing to do with people at the podium. So there must have been some confusion there. I think information, I think what was stated was there are public records on the website that are readily available, and notices. I think where the work comes in is digging through email. So again, the speaker might have been confused on that. And the comment about the planning commission, this isn't the planning commission, this is the board. We don't oversee the planning commission, they're a separate body, and I don't really understand those comments. They don't seem to be germane to this meeting.
Any other comments?